Is this publishable now, or is that controlled inside?
Yeah. What? Ray can just announce that y'all redacted and then ask to make it an exhibit. So.
It's already an exhibit, it says to be substituted.
There you go.
Yeah, okay, thank you.
They're gonna make an announcement before.
They are going to, can you remind them?
Yeah,
Do you want this sheet back that you took out?
I need to go back in there.
Sir? Is that, need to come back?
The one I took out, I feel late.
Okay. Just take it to the back, 'cause I think that's the last sheet.
they were doing it this way, so it could go back. All right, attorneys, I want to make sure I'm right. Thumb drive discs stay in here. They do not go back, right? Okay.
All rise. This circuit court of Dixon County is now in session. The Honorable Judge David Wolf presiding. All ye have business with this court, draw nigh and ye shall be heard. God bless the United States, this state, and this court. You may be seated.
All right, good morning, everyone. We are ready to...
Recording in progress.
First thing we'll need to do is to consider the request for special jury instructions that have been filed by both sides. The first one that I'll take up is the one that was filed by the defense, and I believe they filed it in regard to the initial charge of the court, and that was the jury charge requested having to do with the fact that in Tennessee, a person cannot be convicted based solely on the uncorroborated extrajudicial confessions or admissions. And it goes on to set out essentially the bishop's standard for corroboration of a confession, including the definition of substantial evidence, prima facie evidence, corpus delicti, and so forth. So, Mr. Lockhart, I'll consider that, and then I'll also consider your request for the Tennessee pattern jury instructions, criminal jury instructions number 42.14 regarding the cause of death. If you would like to address those issues, we'll deal with those first.
Your Honor, in regard to the requested charge on the bishop standard, the only way that a jury will know how to, under the law, evaluate a confession that has been alleged to be false is to follow those rules. In other words, the jury could go back, as the charge is now, and say, well, he confessed to Agent Boyd and Faulkner, and then he told his dad he did it, he told others he did it, he's crying and saying, my dad's going to kill me. Several other extrajudicial statements were made after his confession. And Bishop and the other cases make it clear that those extrajudicial statements cannot be considered in regard to whether or not the confession is corroborated. And so that's imperative that the jury know that, so that they'll know how to apply the law and not go back and say, well, he admitted so many times, we think that corroborates the confession. The other request in regard to the corpus delicti is simply what the law is. And then
Let me interrupt you, and I apologize. I'm
Yes,
going to
sir.
let you finish. In this pattern jury instructions, it talks about, in the second paragraph, the defendant's conduct need not be the sole or immediate cause of death. The acts of two or more persons may work concurrently to proximately cause the death. It goes on to say, however, it's a defense to homicide if the proof shows the death was caused by an independent intervening act or omission of the deceased or another which the defendant, in the exercise of ordinary care, could not reasonably have anticipated as likely to happen. It goes on to talk about a possible inclusion was if some other circumstance caused the victim's death unrelated to the defendant's actions. That would be a defense to homicide unless the circumstance was the natural result of the defendant's acts. And then it goes on to say, if you find the defendant's act, if any, did not unlawfully cause or contribute to the death of the deceased, or if you have a reasonable doubt as to this proposition, then you must find him not guilty. My question to you is, what proof is there in the record of any other person causing the death? I understand there were implications, inferences, and so forth. I'm asking for you to point to the record as to any other proof of any other person causing the death other than the confession of your client and these other admissions.
Well, first we have an accomplice, a party to the crime, who assisted, according to his testimony.
And who is that?
That would be the 11-year-old older brother to Joe Clyde, Alex Nolan. He is certainly a possibility that can be pointed to. In fact, the state, in their interrogation, asked questions about whether Alex did this or Crystal did this. So there is certainly circumstantial evidence and some direct evidence. Alex Nolan puts himself at the scene, according to his testimony, of the homicide. And he assists our client, according to his testimony, in that crime. So
He assisted your client, according to his testimony, because your client allegedly threatened to kill him if he didn't, correct? That's what he said.
yes, Your Honor.
I understand.
Yeah.
Okay.
If he were charged, he could argue duress, certainly. But that doesn't mean he's not an accomplice. That, if he were charged, a trier of fact would have to make a determination after hearing the evidence. But he is certainly someone we can point to and say that he was there and he had the opportunity and he at least assisted in the commission of this crime. So we think that the state could, the jury could find that. The jury also could find that there's circumstantial evidence that he did, the victim, Joe Clyde Daniels, did go down to the road and he could have been killed by someone in a vehicle. He could have been abducted.
Other than this supposed finding yesterday afternoon of some sort of a car part, which is completely inadmissible in this trial, other than that, what evidence is there that this young man went down and got hit by a car? What evidence would produce for this jury to consider that fact? Other than supposition, inference, and so forth, what evidence was there introduced?
Your Honor, The testimony that a young child is walking on a dark road at night that's been testified to as being a high-traffic road and a shortcut going to and from Humphreys County, that is evidence that would be a reasonable hypothesis. And the jury may reject that as a reasonable hypothesis, but certainly if we're allowed to put on our defense, that's something we should be allowed to argue in this case.
You mean by to argue, if you're allowed to put on your defense, meaning, of course, the case is closed, there is
Now,
no other.
putting on a defense under the due process clause includes the trial, the jury instructions, whether or not you get fair jury instructions. I contend that that's all covered under the due process clause until a jury returns a verdict. If the jury comes back in and asks questions, we'll have to address those.
I agree that every defendant is entitled to fair and legal jury instructions. My question, I think, was about your wording about if you're entitled to put on a defense. The case is closed. It's now just going to be argument. The jury's been instructed that arguments of counsel is not evidence. So I'm concerned about misleading the jury into thinking that whatever is said in closing argument should be considered as evidence of the case. You can certainly argue the inferences. You can argue the facts of the case. You can argue what the evidence has shown and how you interpret it. But I'm concerned about this language of this. But I want to let you finish, and then I'll hear from the state. So go ahead.
The other reasonable theory would be that the child was abducted, because the child has not been found anywhere. That is strong circumstantial evidence that the child, when he did go down to the roadway, was abducted. And that would explain the child's body not being present anywhere in this case. The circumstantial evidence is that within minutes, law enforcement arrived after the 911 call, and from that point forward, you've got hundreds of volunteers, you got officers, you got helicopters flying over, airplanes with infrared. There's been no proof whatsoever in this case as to our client going somewhere, retrieving a body, and doing something with it. None. It would all require speculation. That is strong evidence that the child was abducted. Because if the child is not here any longer, and there's no proof as to how the child was removed, then abduction is a very likely theory. And I think that also comes under that evidence of someone else. The more important charge that I was addressing was the corpus delicti charge. And the Tennessee Criminal Trial Practice Series by Mark Ward sets out in section 22.7 exactly what the standard is. And so we submit the jury needs to be instructed as to this, because right now, under the instructions as they are, the jury's told nothing about corpus delicti, what has to be proved. The jury needs to be instructed in regard to this, so that they'll understand to meet that corpus delicti, they have to show what's set out in the instruction requirement, and also in the case law that says the death of the human being and the criminal agency in producing that death has to be shown. And it says implicit in that is a requirement that the state prove the death was not occasioned by natural causes, by accident, or by the deceased in person. The most important part of the law in regard to corpus delicti is if the jury finds the evidence is circumstantial only, which we contend in this case it is. There's been no testimony that anyone saw the defendant kill the victim. And there's been no testimony that the victim, when removed from the house, was deceased. We know the defendant's confession that he killed him, put him in a trunk, and took him away. We know that's false. That's been proven in this case. So in order for the jury to understand what law they are to apply to a confession when it's alleged to be false, and also to understand what lie to apply in regard to corpus delicti, and to understand what that means, this has to be charged, because the current instructions would allow the jury to consider additional extrajudicial statements made by our client. They would have no instruction in regard to the fact that in regard to corpus delicti, that the state has to prove that the death was not occasioned by natural causes, by accident, or by the deceased in person. And so we submit we would not get a fair jury trial if a jury is allowed to go back and make a decision in regard to false confession and corpus delicti without being given instructions as to how to apply the law to the evidence in that case.
Thank you. Mr. Krabs, we'll let you argue first in response to his request, and then I'll consider your request.
In response to Mr. Lockhart's request, I'm asking first that the Bishop issue be completely disregarded. I mean, there's no application of the Bishop standard to the jury instructions. I mean, that is a sufficiency test required to be undergone by Your Honor. Second, there has been zero proof that the victim in this case was kidnapped, that any of these things which Mr. Lockhart just suggested, there's zero proof of that. I'm going to equate that or relate it to someone arguing for a self-defense instruction. I mean, there would have to be some proof put on that someone acted in self-defense. Now, equating that over to this case, there's been zero proof put on. The defense chose not to put on any proof. None of these witnesses, not one, testified in any way that Joe Clyde Daniels was kidnapped or killed by any other means other than the defendant, not one. So that request should be denied. And then going into my request for instructions, they were kind of based on whether or not Mr. Lockhart's request would be applied. If they are, the state is requesting that an instruction be provided that it's not the law that the cause of death must be scientifically proven. It's not. And what I mean by scientifically proven is by an autopsy. And two, it's not the law in the state of Tennessee that we are required to produce a body. I mean, someone can be convicted of murder simply by circumstantial evidence alone.
Well, first of all, the request to include in the pattern or in the charge to the jury the so-called Bishop standard that's been talked about a great deal in this case is not warranted in this matter as far as this court is concerned. My basis for stating that is the unreported case of State versus Hill from 2017 Court of Criminal Appeals decision, which is cited at 2017 Westlaw 532481. And in that, Justice Montgomery of the Court of Appeals dealt with the very issue that we have here. And that was an argument that the statements of the defendant, which were in that case an admission against interest, were not properly corroborated at trial, and that there should have been an instruction to the jury on the Bishop standard. The court dealt with the question of whether or not the modified trustworthiness standard had been met in the case. And it went on to state in the last section of that decision, we conclude that the defendant's statements to Ms. Halsinger and Mr. Allen were adequately corroborated pursuant to the modified trustworthiness standard. We likewise conclude that no jury instruction was required because whether the statements were adequately corroborated is a question of law for the trial court, not the jury to determine. Likewise, the admissions against interest pattern jury instructions provided by the trial court address the juror's duty to determine whether the defendant made the statements, and if so, to determine the truth of the facts. The defendant is not entitled to relief on this basis. The situation we have is identical in this case. The defendant gave a confession. Whether that confession is or is not true is a matter for the jury to decide. And the pattern jury instructions regarding a confession are included in my draft of the final charge. And I have stated in those instructions that evidence of a confession has been introduced in this case. A confession is a statement by the defendant that he engaged in a conduct which constitutes the crime charged and is an acknowledgement of guilt itself. The court has ruled that the confession is admissible in this evidence, but it is your duty to judge its truth. In so judging, you should consider the circumstances under which the confession was obtained, as well as any evidence which contradicts all or part of the statements made. You must consider all of the statements made by the defendant, whether favorable or unfavorable to him or her, and you must not disregard any of them without good reason. If the evidence in the case leads you to believe that the confession or any part of it is untrue or was never made, you should disregard it or that portion that you do not believe. And it says you are the sole judge of what weight should be given to those portions of the confession which you believe, and you should consider them along with all of the other evidence in the case in determining the guilt or the defendant's guilt or innocence. And in this court's opinion, that jury instruction, which is the pattern jury instruction on confession, meets all of the necessary requirements for ensuring that the jury has the evidence regarding their role in the matter, and that for that reason the request by the defendant to include the definition of the standard that this court had to apply in determining whether or not corroboration of the confession was sufficiently met would be confusing and unwarranted, and for that reason that portion of your request is denied. Regarding your request regarding the corpus delicti or body of the crime, do I understand correctly that if the state doesn't necessarily oppose the language of corpus delicti, I'm looking at the defendant's request to define corpus delicti and go on to talk about in homicide cases, the corpus delicti consists of two elements and so forth, but if that is included, then you're asking that your instructions be included to sufficiently define it.
Yes, sir.
All right, then I will include the defendant's request starting with corpus delicti literally means the body of the crime, and conclude the defendant's request as at this paragraph stating in the homicide case corpus delicti consists of two elements. I will likewise include the state's request for definition for jury instruction rather, and the way I intend to include that is I will state your instruction number 2 first, that the state must prove the death of a human being beyond a reasonable doubt. The state may proffer testimony of an eyewitness to the act or rely purely on circumstantial evidence. The state is not required to recover or produce a body. Having reviewed the case law submitted along with that request, I found that is a legitimate request. Then after that, immediately we'll state the law does not require the state of Tennessee to scientifically prove the cause of death. Again, having reviewed the case law that was submitted in that request, I found that request to be as well admissible. Ms. Fry will need to make those changes and include that language in the charge. Are you wanting to look at the charge after it is finally prepared before you begin your closing argument?
I would just, we've got this far, no hiccups, so.
Yes, I still need to address the court. The court didn't afford us an opportunity to be heard.
Oh, certainly, yes. Go ahead.
I understand the judicial economy and trying to get it done quick, but we need to address that. Your Honor, the instructions as they are now do not say the state has to produce a body. And the instructions define direct evidence and circumstantial evidence. And the state can argue pursuant to those instructions. There is no jury charge in TPI that says the state doesn't have to prove there's a body. It's a weakness in their case, I understand, and so you would like the jury charge that, but that's not in the pattern jury instructions. The instructions that says to scientifically prove the cause of death, that would lead the jury to believe that proof of death can either be scientifically or otherwise. They've introduced scientific proof in this case, and they've introduced lay witnesses. So in that regard, if that's going to be in there, I would ask that it state the law does not require the state to scientifically or prove by any other means, excuse me, the body. I would ask the court simply instruct the jury that the state is not required to provide a body or an autopsy report, that they can look at direct and circumstantial evidence in determining if there's been a death. I think that instruction 2 the state must prove the death of a human being beyond a reasonable doubt. That is sufficient. They don't have to be told how the state can do that, or what the state can rely on or not rely on. The simple statement that the state must prove the death of a human being beyond a reasonable doubt covers it without covering anything else. And the court didn't address our Tennessee pattern jury instruction, which I submit covers this perfectly well. So we don't have to reinvent the wheel on this. The Tennessee pattern jury instruction that is used all the time addresses this. And the pattern jury instruction is given in murder cases, as that is, out of abundance of caution. Is there proof that somebody saw the child abducted? No. But is there proof the defense can argue that something else happened to this child? That's a reasonable theory, absolutely. And so we contend that rather than reinventing the wheel, use the Tennessee pattern jury instruction we provided, because it covers all of this.
Thank you. As I stated earlier, I had reviewed the request for jury instructions by both of the parties prior to this hearing this morning, and I have made my ruling, and I stand by that ruling. I think that the inclusion of the corpus delicti is not always included in our jury instructions in a homicide or a murder case. Mr. Lockhart has requested that I include the corpus delicti charge in this charge to this jury. And part of that is that in homicide, it states the following: in homicide cases, the corpus delicti consists of two elements, the death of a human being and criminal agency in producing that death. Implicit in the latter is the requirement that the state prove the death was not occasioned by natural causes, accident, or the deceased in person, or by the deceased in person. And that I'm including, and while he says I did not consider his pattern jury instructions, I did consider them, and I've said I would grant those. But the state's request is also based upon case law that the state of Tennessee recognizes, and those are that the law doesn't require the state of Tennessee to scientifically prove the cause of death. That's absolutely the truth. That is the law in the state. Second instruction, that the state must prove the death of the human being beyond a reasonable doubt. That's part of the corpus delicti. The state may offer testimony of an eyewitness to the act or rely on circumstantial evidence. That's part of the pattern and jury instructions as well. And it goes on to say the state is not required to recover or produce a body. That is clearly the law in the state of Tennessee based on the case law. I think in this case that the evidence is warranted that it does not prevent the defendant from arguing their theories of the case and whether or not they think they can point to any evidence in the case that would support their theory. But my ruling is that those two requests by both the defendant and the state will be included in the final charge, and we're going to make those changes. And other than that, we have prepared a verdict form for the jury's assistance in reaching a verdict because of the multiple counts in the indictment and the multiple lesser included offenses that will take them through each count from greatest to lesser included, and assist them in determining how they're to go about their business. I believe that we've prepared that and have submitted that to both counsel for the defense and for the state. So we will take a recess while Ms. Fry prepares the final charge, and then we're going to need to print 16 copies for that. I have advised the jury, and the jury has requested that when I finish the charge, the 4 alternates will be randomly chosen and excused. This is after you've made your closing argument, and I've charged them. The 4 alternates will be randomly chosen and then excused. We're going to load them in a van and head them to Chattanooga. Their request is that their names not be read out loud into this because they don't want to be targeted on social media, and I don't blame them, because that's apparently what has happened in this case with other witnesses or other individuals. So for that reason, their names will be not given, but I will use the numbers that they were given or assigned at the time of their jury selection. So I will be randomly picking a disc from this box that will have a number on it. I will read that number out. That person will exit the room and go into the jury room to be escorted to a van to be removed from the courthouse, and their name and address and information will not be admitted or not be published to anyone as far as this court is concerned. They have requested anonymity based upon the fact that everyone's aware of social media is, in this case, they were told this in jury selection, but the social media is, in this particular case, can have a great benefit to people, but it can also have a negative. And so to protect their privacy, that is what they have requested, and I am agreeing to that. So we will allow them to leave, and then those remaining 12 will then be discharged to begin their deliberations. When they have finished their deliberations, just so everyone understands, they will be they will be loaded on the commercial bus that we had used to transport them up here with their belongings, and they will be escorted back by the Sheriff's Department to Hamilton County, where they will be discharged. So I think that's pretty clear how we're handling it from here on out. So if there are any other questions, we will have this prepared in just a little while and give you a copy of it so that you may begin your closing arguments. We'll stand at recess until that time.
Do you want us to address what we've found in the jury charge that we think needs to be changed or addressed?
Yes, certainly. I thought
Can we
we
do
were
that
doing
now?
that. I apologize. I didn't give you an opportunity to talk about what I had drafted. I only gave you an opportunity to talk about what you were requesting.
On page 2 of the jury instructions, 6 lines down from the top, we would request that after assault, that the court also charge the B misdemeanor offensive contact assault as a lesser included. And I can, Your Honor probably knows that's been charged in all kinds of horrendous crimes, but it's certainly out of the abundance of caution in regard to lesser included. I don't know, do y'all oppose that? State has no opposition.
All right, we'll include it with no opposition.
On page 22.
Well, let me back
Yes,
up.
sir.
That, then we would also necessarily include it in count 2.
And all the
which
lesser
is-
included, yes, Your Honor.
Right, all right.
Yes, Your Honor.
Page 22.
Yes, Your Honor. And it could be that things have changed, but 1, 2, 3, 4 lines down, the defendant is guilty of the lesser included offense of knowing aggravated assault. My understanding is aggravated assault includes knowing, intentional, or reckless. And
He's looking at the first rough draft that's been taken out.
All right, that's been taken out
Okay.
apparently.
all right.
I don't actually have in my hands the copy that you are referring to. because
Yes, Your Honor.
we've gone through about 3 drafts thus far.
Yes,
Excuse
sir.
me.
And that's
Anything else?
all that we've noticed. The state may have noticed something also. Well, maybe not.
Judge, I have already passed up to Ms. Fry in the jury verdict form, voluntary manslaughter, and it says if you find
All
it on page 3,
Thank you for pointing that out.
if you find,
We'll take care of that change. That is a typographical error.
But we have one change that was submitted last night on aggravated abuse, aggravated child abuse. It should be or instead of and/or.
Have you made that change?
I put and/or.
Yeah. Isn't that correct, Mr. Kimball? I mean, that's what we think, but
So you're saying instead of and/or, it should just be are,
yes,
or,
yes.
We agree.
or as we in the country say, are?
Yes, sir.
All right, then that will be agreed to. Well, all right, then thank you for your input on the charge. We'll make those changes. We'll give you a hard copy to go by. Now, I don't mind giving one or two for table, but giving a charge for everybody sitting at the table may be a little difficult. So we're going to have 16 for the jurors, one for me, and a couple for each of the tables, and that should be sufficient. So we will then stand at recess until such time as we're able to get this ready. So.
All rise. This court is in recess.
Mr. Court Officer. Can you remember log reaching the microphones? No one.
Good morning again, ladies and gentlemen. And before we get started, I do just want to tell you thank you for being here. I know you've been away from your families a long time, traveled a long way. You've been really patient with us, and it's obvious that you've all been attentive throughout the trial, and I know everyone here appreciates that. So I just wanted to say thank you before we get going. But we're here today to talk about Joe Clyde Daniels. Joe Clyde, he loved his flannel shirts, he loved his cowboy boots, and he loved to eat apples. You heard from Miss Donnerstag, Joe Clyde was full of life. He loved to have fun, and he liked to go to school and to learn. He had some physical and mental limitations. He was developmentally delayed, especially when compared to his peers. You heard that he couldn't speak very well. Full sentences were not something that he'd learned to do yet. He scored in the first percentile of gross motor skills, but he was making progress in his time at school. Ms. Donnerstag and other teachers at Centennial were working hard with him, and he was making good progress. But then all that came to an end on a dark, cold, stormy night in April of 2018. And to tell you a little bit more about that, I want to refer you to the testimony that you heard of young Alex Nolan. Alex testified that him and Joe Clyde got home from school on April the 3rd, a little after 3 o'clock. You saw the bus video. You saw them getting off the school bus. Aunt Joyce met them at the end of the driveway, and they walked up to the house, and it was a normal day. It was a normal afternoon. Nothing was out of the ordinary. They ate supper, and eventually they went to bed. You heard testimony that Joe Clyde and Alex slept in the master bedroom, right here. This is the living room, dining room, kitchen, and the other bedrooms. So the testimony was that Alex and Joe Clyde watched TV and they fell asleep in the master bedroom. Alex was awakened when Joe Clyde had peed in the floor. He walked to the other end of the house, told the defendant and Crystal Daniels what had happened, and they told him to go back to bed. So Alex went back to bed and went back to sleep. And you heard from his testimony, the next thing that he knew, he was awakened by a loud thump. He said, I let things cool down for a few seconds before he went out to see what was going on. And as we've spoken, the master bedroom is right next to the living room. He looks out the doors into the living room, and what he saw would change the course of his life and many others forever. He saw the defendant, Joseph Daniels, standing over the lifeless body of Joe Clyde. He saw Aunt Joyce and Noah in the kitchen, and Crystal hiding at the other end of the house, just peeking around the corner. Later, a few minutes later, a few seconds later, he saw the defendant pick up the body and carry it outside. They went out the back door of the house, and Alex said he followed him a little later. After a few seconds, he went out to see what was going on. He said that the defendant laid the body of Joe Clyde in the front yard and then was walking all around the backyard. The defendant threatened Alex. If you don't help me, I'm going to beat you. So Alex opened the trunk and suggested putting the body in there. The defendant decided not to do that. He picked up the body and walked down the driveway. We can't tell you why he decided to carry the body down the driveway. We don't know. We know he did. Alex said he did. We also know that Jeannie Jones saw him down the road about 0.8 of a mile. She never wavered from saying it was him. She said he wasn't looking directly at me, but I saw him. Daniel McCormick saw somebody down there at the end of the driveway. We can't tell you if he saw the defendant, if he saw Joe Clyde, or if he saw Alex. We know that all three of them were out there that night. We know the defendant was hiding the body. We know Joe Clyde was out running for his life. And we know that Alex walked to the end of the driveway trying to see where the defendant was carrying his little brother's body. After that, after Alex watched the defendant carry the body south on Garner's Creek, he went back to the house. And he said, I tried to go to sleep as his young mind was trying to process what he'd seen. He said it was hard, but eventually I did. I was able to go back to sleep. You saw Alex testify. He was 8 years old when this happened. And he said, I didn't tell the truth in the beginning because I was trying to protect him. But that was a lie. He said, I'm here to tell you the truth now. I'm here to tell you what happened. And here's what the defendant says about Alex.
Alex, yeah, he's a good boy. He doesn't lie. He tells the truth. It's always admirable. We taught him not to lie to anybody, tell the truth. And I know they interviewed Alex and made sure he told them everything.
The defendant says, Alex is a good boy. He doesn't lie. I know they interviewed him. I'm pretty sure he told them everything. Alex came in here this week and he told y'all everything. In the face of his stepdad, in the face of his grandparents, being questioned by lawyers, he came in and he told you what happened. Now, he said that he watched Joseph Daniels carry the body down the road. And there's been a lot of things said about the body and about where the body is. And if you recall, almost 2 weeks ago at the convention center, I told you at the end of the trial, you're not going to know. We can't tell you. The law doesn't require us to tell you. He says, I laid him in a field. Other times he says, I buried him. Other times he says, I threw him in the river. Other times he says, I put him in a pond. We can't tell you where the body is. We don't know if he buried him. He put him in the river. He put him in the pond. He put him in a dumpster somewhere like Love's Truck Stop or some other place. But what we do know is what Alex saw. We know what the defendant confessed to. We know what Jeannie Jones saw. So the night of April the 3rd, 2018, Alex goes back to sleep. And then he's awakened by the defendant the next morning, the morning of April the 4th, and the defendant's lie begins. The defendant concocts this story. Well, Joe Clyde, he must have just wanted to escape in the middle of the night. And think about that word, escape. Someone's child escaping from your house, from their own home. Escape. It's an interesting choice of words. But he must have escaped. He must have pushed the coffee table from the living room over to the door. He must have climbed up on the coffee table. You heard Miss Donnerstag say he probably couldn't have done that. He struggled making big steps like that and climbing like that. You heard Alex say, I've never seen him climb on the coffee table. But he must have pushed the coffee table over, he must have climbed up, he must have found the key, and he must have got the key in the lock, and he must have unlocked the lock. You heard the testimony. He struggled to unlock that toy plastic lock with the great big key that we brought in here and showed you. But this lock that's up near the door, up near the top of the door, over his head, he must have somehow got unlocked. He got the lock out of the latch. He put the key back on the mantle, because, of course, kids put keys back where they go and stuff back where they go. He threw the lock down in the toys, and then he pushed the coffee table back where it goes. And he did all this without making any noise. Now, Ms. Donnerstag and even the defendant have all said Joe Clyde was not quiet. When Joe Clyde was doing something, you knew it because he made noise. But this night, he must have done all this without making any sound. He didn't slam the door when he escaped because the defendant testified we can hear the door shut. But he must have escaped. Despite all odds, all these things that no one's ever seen him do before, he learned how to do all those things in the middle of the night and escaped. And based on that statement, one of the largest searches for a person in Middle Tennessee ensued. You've heard that there were hundreds and hundreds of citizen volunteers. There was over 20 law enforcement and emergency responder agencies that came and helped look. There was helicopters flying grid patterns. The TBI's airplane with its infrared camera was searching. You could see deer walking. You could see cows laying in the field. Ponds were drained. Sonar was run through ponds. The area was combed. No Joe Clyde. And we've heard testimony about the large search area. And right here is the area of Harris Road. We know that the defendant's house is up off of the map. And he's down here. The search extends down into Hickman County. You can see right here, it says Dixon County. Right here is Hickman County, and that's the county line. The defendant's house is up north in Dixon County. The search extended all the way out into Hickman County. From 112 Garners Creek in Dixon County, about 6 miles, I believe, was the testimony of the search, and it extended down into Hickman County. There's a picture of the latch, the lock, the key, all that Joe Clyde, according to the defendant, learned how to operate in the middle of the night so that he could escape. The TBI, once suspicions started getting raised, questions started getting asked, there was a search of the house done on April the 7th. This is the exhibit from Greg Fort. He says the VCR team responded to 1112 Garners Creek Road in Dixon, Tennessee, Dixon County, and they conducted a search. One of the things that was noted, as you'll note, there wasn't a whole lot found. You heard testimony from Agent Fort, though. He said it looked like the house had been cleaned. It had been vacuumed. It had been picked up. There was a possible bleach stain. He said, we can't tell you for sure whether or not it was bleach, in front of the coffee table in the living room. And the search goes on. But on April the 6th of 2018, the truth begins to come out. Agent Joey Boyd interviews the defendant, and he begins to come out with the truth of what happened. He beat his son. He threw him on the coffee table. He killed him. He disposed of the body. Detective Trevor Daniel takes the defendant out to McElhaney Road. He makes several comments on the way out there. I want the donations to go to his funeral expenses. Why did I kill my son? Alex was a good boy. He doesn't lie. And many more statements. He gives a written statement later on that night. I lied about where I told you the body was, but I killed my son. I disposed of the body. The next day, April the 7th, the defendant requests TBI to come talk to him. So they do. He says, I killed my son. He's consistent with that truth. But I think I threw his body in the river. So they drive down to the Piney River and multiple rivers. The Piney River specifically, the defendant says, I think it was here. I believe it was 7 or 8 out of 10 sure that he threw him in the Piney River. The defendant's driven back up where he talks to his dad. This is not a police questioning. This is the defendant speaking with his father, and what does he tell his father? I killed Joe. Ladies and gentlemen, he is consistent that he killed Joe Clyde. The place where he put the body changes. He didn't tell where he put the body. But think back through the witnesses. Has there been one single witness who testified that this was a false confession? Has there been one single exhibit saying this was a false confession? There's been inferences made by attorneys, but think back through the proof in your mind. And then think back through the statements that were made, because they were all consistent, and he killed his son. I want to get into a little bit now of what we have to prove. This is some of the jury instructions that the judge is going to read to you. Premeditated murder. The defendant unlawfully and intentionally killed the victim, Joe Clyde Daniels. We know he did that. We've gone through that evidence and that testimony. He did it with premeditation. We haven't talked about that yet. Let's talk a little bit about premeditation. What is that? Premeditation is an act is done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. He had to form the intent to kill Joe Clyde Daniels before he actually killed Joe Clyde Daniels. So the question for the jury, for y'all, is, did he do that? And I want to take you back through some of the other proof. And this is hard to see, but it's been made an exhibit, and it'll go back with you. The defendant lost his job, quit, and the resignation was accepted and made it effective immediately on February the 28th. And that began what was a downward spiral for Mr. Daniels. You sat and listened to some very explicit messages, which we're not going to go back and rehash, but you heard them, you know what they said, between the defendant's wife and Crystal Daniels. The defendant's wife, Crystal Daniels, and a Thomas Richards. Now, we submit that the evidence would show Mr. Daniels found those messages. And here's why. Again, on the screen, it's a little difficult to see, but it'll go back with you. You remember the last of the explicit messages ended March 28th. And on the screen there, it's Thomas Richards says, KK Night. Then on 3/29, he messages Crystal Daniels and says, hi. No response. 3:30, what's up? No response. Then again on 4/1, yo, no response. The defendant, after reading those messages, knew, or at least he thought, based on his reading of those messages, that his wife was going to leave him. She wanted another man. She'd started an online relationship with this man. But importantly, he knew she needed Joe Clyde to be able to do that. Do you remember the message she sent to Mr. Richards? I get $1,200 a month for Joe Clyde. With that and a job, do you think I can make it? That planted the seed in the defendant's mind. My wife can't leave me without Joe Clyde because she needs the $1,200 a month she gets for his disability to be able to make it. And then on March the 30th, remember the responses were on the 29th, 30th, and April 1st. The hi, yo, what's up? In the middle of that, on March the 30th, on the defendant's phone, he begins searching anonymous paternal test and then visits a website about paternity testing. Paternity testing where the mother and father don't know. That was done at 11:51 p.m. and 11:52 p.m. on March the 30th. And then at 12:06 a.m. on March 31st, some 14 minutes later, he sends a message to his mother. F this world. By the time you read this, I'll be 6 feet under. And then on April the 3rd, he's visiting websites about airplane tickets, Greyhound bus tickets, rental car, some of that being in Wichita, Kansas, which is where Thomas Richards lives, where his wife was planning to go with Alex on a trip. And then on 4/3, Mr. Daniel's wife texts him and says, "Where are you?" And he says, "Mental health." And it's important to note, if you recall from the testimony, at this point, Big Joe and Belle were gone on the truck. They weren't home. The seed was planted that Crystal needed Joe Clyde's money to be able to leave the defendant.
Shut the door. I moved the coffee table.
I let him out. I shut the door. I moved the coffee table.
When you called him, he was almost at the road. And did you carry him back in or walk him back in?
I walked him back in.
You walk him back in, were you holding him to him?
Yeah.
You get back inside. You spanked him some more.
The defendant let Joe Clyde out. He put him out. He closed the door. He moved the coffee table. He went out and caught Joe Clyde down by the road and took him back up to the house. Premeditation, ladies and gentlemen, I submit to you, began to be formed when he found those messages, and it was formed on that trip back up to the house. Because what happened when they got back to the house? The defendant killed Joe Clyde. Alex walks out, sees the defendant standing over Joe Clyde's lifeless body. Felony murder. That the defendant unlawfully killed the victim, Joe Clyde, and that the killing was committed in the perpetration or the attempt to perpetrate aggravated child abuse, and that the defendant intended to commit the aggravated child abuse.
How'd you beat him?
Fell on the floor.
What else did you do?
Spanked him. Was on the floor. Countless times.
How else did you beat him?
Fell on a coffee table.
How'd you beat him? I threw him on the floor. I spanked him countless times. I threw him on the coffee table. Might that have made a thump that woke up young Alex?
So you never told her exactly what happened, did you?
No.
Why not?
I was afraid that somebody was saying,
Okay.
I need help. I need help. I've been to the hospital several times for something like this.
go any further, I want to make a note here. Did you hear that last statement? Why did I kill my son? Think about the other statements that you've heard the defendant say. That boy, the boy. But here, as the truth is coming out, it's why did I kill my son? He says he never told Crystal exactly what happened because he was afraid someone would find out. Aggravated child abuse requires the defendant knowingly, other than by accidental means, treat a child in such a manner as to inflict injury. We know that happened because Joe Clyde was killed. The act of abuse resulted in serious bodily injury, that the child was 8 years of age or less, or vulnerable because the child was mentally defective. You have heard the testimony. Joe Clyde was 5 years old when he was killed. You've also heard the testimony about Joe Clyde being developmentally delayed.
Okay, come here, letters. And go. Joe. Joe. Hey, I want to hear you. A. Uh-oh. I don't hear. Say it. A. Your turn. E. Good job. E. Good. E. What's next? A. F. Ah. Good.
Joe Clyde was slower than some of his peers, but he was making progress until the night of April the 3rd of 2018. You heard Alex testify as to what he saw that night. You heard the defendant's consistent confessions to killing his son. You heard from the statement between Noah and Aunt Joyce. Joe dead, Joe dead, Joe dead, was Noah's statement. Aunt Joyce's reply, yes, baby, Joe dead. And ladies and gentlemen, that's why we're here. When you go back to deliberate, we're going to ask you to return a verdict of guilty, because the night of April the 3rd, 2018, that man killed his son on a cold, dark, stormy night and hid his body. Don't reward him for concealing the body. He killed his son. We ask that you would find him guilty of it.
Defense ready?
Ladies and gentlemen, thank you for being here. Thank you for coming all the way up from Chattanooga. Thank you for being patient. It's been a long trial. I ask that you be patient because this is probably going to be a pretty long closing argument. So if you could, just bear with me. This trial starts with a family story of what happened on the night of April the 3rd. The family story starts with Joe Clyde peeing on the floor. And remember, that's based off of the family story. The state could have proven to you that he had peed on the floor. They literally tore the carpet out of that house. But they didn't do that. And there are going to be a lot of components of this story where they say, you have to know these things happened, even though we didn't prove them. But that's the first one. The first one is that they have not proven that Joe Clyde even peed on the floor. There's a lock. There's a lock on the door, and the defense is not going to contend that Joe Clyde could open that. He didn't have the motor skills. You've seen the videos. You've seen how he
interacts with things. He wasn't able to unlock that door. That door was unlocked. But what that lock is proof of is the fact that Joe Clyde did leave that home. There were times when he was getting out of the house. The family had put something in front of the front door, and they had added a lock to the back door. This was not an elaborate scheme. This was a child who got out of the home. The state spent a lot of time trying to disprove that portion of the family story, trying to tell you that it's not possible for him to do that. But remember that the state's burden is to prove something happened, not to poke holes in the family story about what happened, not to say, well, that doesn't seem realistic. They're supposed to prove that a murder occurred. Let's talk about the coffee table. The story about the coffee table begins with Mr. Daniels saying that when he woke up that morning, the table was moved. He doesn't say the table was in front of the door. He doesn't say it was right there so Joe Clyde could have climbed up on it to get the lock. He said, when I got up that morning, I had clothes for Alex, I had clothes for Joe Clyde, and I went in there, I set them down on the coffee table, and something strange was going on. It had been moved. When directly asked about it, they say, could Joe Clyde have unlocked that lock? Could he have climbed up there? And Mr. Daniels, talking to Detective McCartney, says, that's a good question. I've never seen him do it. I don't know if he could do it. I think he could. And my wife says that she's seen him climbing up there and stuff, and he watches me, but I don't know. The next morning when he wakes up at 5:30 and says his child is missing, the state put on the bus driver, Mr. Longden. He says he saw Joseph Daniels in his car talking to other children in the neighborhood. He had pulled down the road. He was asking them, had they seen Joe Clyde? The state asks you to pay attention to his actions that morning. Watch where he's going. See how strange it is. The testimony and proof has shown that that morning the police arrive. They've already searched around the house. They're driving up and down the road trying to find where the neighbors, if anybody's seen him. And the police start searching. And so Mr. Daniels is a father of a child. He continues to search. He knows he's not right around the house. So what does he do? He gets in his car, he starts driving around. That's not suspicious. That's a father looking for his child. The state has shown you 2 videos of that vehicle leaving the house and then coming back, and they're obviously inconsistent. It shows him leaving, going south, and then it shows him coming from the north back in with Crystal. They've implied that that's some kind of lie because he says that Crystal wasn't in the car with him. But they have helicopters circling the house. They have hundreds of people searching. You've heard testimony that they had their cell phones and knew where they were. Knew if they were in the house that night, knew where they were that day, and they gave you no proof as to any suspicious activity as to where he went that day. They've shown you a video of him going south and then coming back in from the north. And they've said, he's doing something weird. No, he's looking for his kid. And at some point, while he's circling the neighborhood, he picks his wife up and drops her back off at the house. Brett Morris and Chad Bailey come in and they tell you that they heard Noah Daniels say, Joe dead. But multiple people have come in and testified that at that period of time, on that day, dogs had tracked his scent to a pond, and they were draining that pond. Not only were they draining that pond, but they had divers and other locations searching ponds for Joe Clyde. The family had to know this isn't evidence of murder. This is evidence of a crisis. This is evidence of a family who have been told to sit in a room because if you go outside, your scent might negatively affect the way the dogs can track. And they're sitting around a house, and they're being told he was tracked to a pond. They're draining the pond. That's not evidence of murder. The state has put a lot of emphasis on the fact that Mr. Daniels panicked and thought that there's a chance Joe Clyde had gotten into the trunk of the car. He's in the house, Mr. Daniels that is, and he's been told to stay there. He calls the authorities and says, "Will you check the trunk of my car?" There's nothing irrational about a father who's missing a child, whose child's been missing for hours, saying, "Will you just look in the car?" Maybe he's been in the trunk the whole time. But the state wants you to believe that that's evidence that he was hiding something. None of that's logical. The idea of murdering your child in the middle of the night and then asking people to come look for you, asking people to come search for him, asking people to go look at where you supposedly put the body to carry it off, none of that stuff's logical. He's looking for his kid. Detective McCartney shows up at the scene. She testified that she showed up sometime slightly after 9 o'clock. She's given access to the home, unlimited access. Walk around, look in the closets, take photos, do whatever you need to do. She searches that house and she testified that she found nothing. Nothing to indicate that there was foul play. She took photos. She then asked Mr. Daniels if he'll show her where he went that morning. She's not helping him search for his kid. She's interrogating him. She puts a recorder on. She asks him questions. They're driving around. They're trying to track where he went. And they know where he went. And they have that information. And it's just not unusual enough to put it up there for you. He drove up and down the road. He drove to a distance that he thought this is about as far, he wouldn't have gone this far, and he turned around. Then he goes to another place. Drives out there until he says, "You know what, this is too far," and he turns around. When that interview ends, you can hear that Daniel McCormick has shown up on the scene. Daniel McCormick is completely independent, has no skin in the game whatsoever. He's just up at Belmont University working, and he comes home. The TBI track and show that he was at the Love's gas station sometime after midnight on the same day that Joe Clyde went missing, and that he bought some Dr. Pepper. They use that information to extrapolate when he would have driven by, and then he gives you a couple of locations where he thinks he saw someone. Now, he's jumped around, but he says a person in the pajamas the kid was wearing, a person less than 5 feet tall that definitely was not Mr. Daniels, and definitely was not wearing the shirt Mr. Daniels was wearing. State put on a woman by the name of Jenny Jones. Originally, she calls in, it's in the CAD report. You'll have the CAD report when you get back there. You can look at it. In the CAD report, she calls in and says she saw a strange man that night. Then, because this is an incredibly publicized trial and publicized events, once Mr. Daniels' photo is up on the television, she calls in and says, that was him. She also said, and Detective or Agent Boyd says, that he was facing the woods and she never saw his face. Then she comes in today and says she did see his face and she did see what he was wearing, but she doesn't describe what he was wearing. She says red shorts and then a white shirt with some blue and red in it. But the state has showed you photos of the day that Joe Clyde went missing. Mr. Daniels was wearing a black shirt with a green alien on it. So she does not know what she saw. going to go out of order of how they were called, but the next person chronologically that should be talked about is going to be Agent Kennard. Agent Kennard comes to the house at 10 p.m. that night and starts to question Mr. Daniels, and you have that transcript. He questions him. At this point, Mr. Daniels has been questioned by first responders. He's been questioned by the search and rescue teams. Trevor Daniels says he's questioned him earlier that day. Agent McCartney questioned him, and likely other people who've been around the area have asked him what happened that night. Not only does Mr. Daniels tell a story of the same family story of he peed on the floor at 11:30, I got up. There are slight changes. It's been 12 hours. He's told the story 10 times probably. And the state wants you to believe that that's proof that he's lying. But he also tells Agent Kennard, I think y'all should start looking at loves. Joe Clyde loved his Nana, and he would have went there. He tells them that when, well, Big Joe's how I'm going to call him, but the grandfather, there's too many Josephs. When Big Joe left in his truck, he took Nana with him, and Joe Clyde loves his Nana. If Nana had been here, he wouldn't have ran away. He loves his Nana, and he was upset when she decided to go in the truck with Big Joe and didn't even go down to Love's with him. So he thinks maybe he went down there. LaVon Chapman Robbins says that she saw Mr. Daniels at around 2:40, 2:50 in the morning. She works at Love's gas station. This is the same night that Mr. Daniels has told Agent Kennard, you should be looking at Love's. What if he went down there? Maybe we should be showing people pictures down there. So he goes down, he buys a pack of cigarettes, he leaves, turns around on Harris Road, and drives back. He's driving slowly. That's been testified to. Who knows why? Maybe he's looking for Joe Clyde. It doesn't matter. He goes back in there and he shows them a picture, and she testified that that was weird that he stayed there so long. But if you look at her statement, Madam Clerk, can I have Exhibit 177? This is what's said. I went inside and clocked in. The man from the red car came inside. I asked him if he was looking for the little boy. He said he was, or that was his son. He had no emotions. He said he was looking for his son. My manager, Lee Gervais, told him that the TBI had been there and that they have a suspect. Mr. Daniels asked for a description. They had a conversation. I don't remember Mr. Daniels buying anything. He showed pictures of his son on his phone. I remember that I did not notice any marks on his hands. He left the store. About 10 minutes later, his father, Joe Daniels, called. I saw his name on the caller ID. He wanted a description of the suspect. He spoke to a manager. There's nothing unusual or odd about a father who can't sleep on the night that his son's missing, who goes in and finds out that a TBI agent may or may not have made a suspect at the store and asks for a description. The fact that you watched a conversation that lasted several minutes makes perfect sense if the man is telling him about what they know about the investigation. He just wants to know what's been found. He wants to know what's going on. He wants to know where his son is. Arguably, when he leaves the gas station, the next thing he's going to do is call his dad. His dad's out of town. He's driving home. He tells him what he heard. It takes about 14 minutes to make it from the Love's gas station to his house. If you'd had phone data, you would know where he went. He calls his father, and his father wants to know, so they call down, and it just shows that the next events in sequence are him calling his dad. Zach Burkhart, the lead detective, took the stand yesterday. And when he's confronted by Mr. Lockhart, the responses are a mirror to the investigation in this case. The defense has argued and maintained that the investigation stopped once the confession happened. If Mr. Lockhart asked him, should something have been done by the state, and it wasn't done, his answer was, Mr. Daniels confessed. That's what the defense means when they say that the investigation ceased. If there were leads and they didn't fit the story, they weren't followed up on. If they didn't follow what was going on with the false confession, then they didn't look into it. The DA gave several other examples of the failings of the state's case through Agent Burkhart. Defense multiple times has talked about different leads that weren't followed up with dogs. The point of that argument is that they had people calling, saying things like, a child's shoes were missing. Someone had stolen shoes off of a porch. Or that a child sighted a kid in muddy pajamas. The TBI didn't follow up on those because there was a confession. They didn't bring the dogs out there and search those areas. There's no argument that Joe Clyde Daniels went north, stole a pair of shoes, walked back and forth through the command center, and then went 14 miles round trip to make it to a place south. No, the point is there were other possibilities. He could have been north, and they didn't follow up on it. He could have been south, and they didn't follow up on it. The other thing that they got, and by they I mean the state, out of Agent Burkhart is the testimony or the Facebook messages from Crystal Daniels. There is no logical connection to Crystal Daniels wanting to have a divorce and Mr. Daniels killing his son. They'd have no proof that Mr. Daniels saw those, and let's say he did see them. What do they say? They say she wants away from him. They say she's tired of him. He's a child. I don't want to be here anymore. I want divorce. I want to move on. The statement from Alex Nolan is that she watched him kill Joe Clyde Daniels. She wants to get away. Why not call the police? Why not tell them what happened? Because it didn't happen. She wasn't going to say he killed their son because they didn't see that. If those things had happened, she wanted out of that relationship. She wanted somewhere else. They also put on pictures of the house that's been cleaned up. It's 3 or 4 days later. The grandmother's back home. The house had been vacuumed. That is not proof of murder. The idea that someone comes home and picks up their house, the toys are all still out there. They're just pushed to the wall. The floor's vacuumed. They're hiding stuff. All right. I'm going to go through this confession. We've got to do it. It's going to take a second. I wish y'all had your copies, but if you want to, you can write down some of these pages. We're going to talk about what makes a false confession. But before I do that, I want to talk about how do you prove something is a false confession? You can prove something is a false confession because all of the things that are said in it are false. If nothing there's true, then it's a false confession. On page 86, Agent Faulkner says, listen to me. They've done a lot of stuff with phones, a lot of phone stuff, phone records. Today, the last couple of days, there's no doubt someone's phone went somewhere during the night, okay? And I don't know if it was an accident, either you or Crystal hurt little Joe, or someone else did. There's no doubt something happened. This interview is taking place on the 6th. And what Mr. Daniels knows at this point is that they have talked to Alex Nolan. They talked to Alex Nolan on the 5th. You watched that video. Mr. Daniels had not. He does not know what Alex has said. I'm skipping over a lot of stuff, but you watched the interrogation. You've read the transcripts. You have transcripts back there. Understand that things that are being skipped over only help Mr. Daniels because he is denying anything happened. There are pages and pages of, I didn't do it, I don't know, but I'm not going to bore you with that. Page 94. This is Agent Boyd. He says, we know things. We know this stuff that's been left out. We need you to have that realization, you know. We need you to tell us the whole truth. He's trying his best to convince Mr. Daniels that they know something they don't. They don't have any information. The only thing they have is the statement of Alex Nolan. He's lying to him. He's bluffing him. He's trying to coerce some kind of anything out of him. Page 110. I'm here for the truth, and if this is Agent Boyd, someone else did something to him, I would be here talking to them, just like you, because I would know that, but Joe, I'm not. I'm here talking to you. He's reminding him, I know and you don't. I know what's happening. You don't know what's happening. I just need you to tell me. Page 124. Agent Faulkner. Joe, little Joe deserves. He's somewhere alone. Think about that. You know where he's at. You can tell us. You can help us bring little Joe home. Joe, be a man. You're better than this, okay? Agent Boyd. That. You know, little Joe deserves more. Joe Daniels, I know that. Agent Boyd, he deserves to properly be laid to rest. You saw this. His reaction was, what? Agent Boyd says, doesn't he? And Joe says, they found him? At this point, the new piece of information that Mr. Daniels is given, or at least that he thinks he's being given, is that Joe Clyde's dead and they know it. Page 127. This is one page later. Agent Boyd, we're talking to Crystal too. We're talking to the other kids. We've done a lot of stuff you don't even know about. There's a lot of stuff happening right now and you don't know about it. So every time you say, I don't know, and I didn't do this, and I didn't do that, I'm telling you the truth when you're not. Don't. When we know those things aren't true, you're digging yourself in a hole. It gets deeper and deeper and deeper. Just more of Agent Boyd lying to him, telling him that he knows something that he doesn't know. Page 131, Agent Faulkner. Joe, somebody in your house did something to little Joe that night, and they took him out and put him somewhere. He didn't leave that house on his own. He didn't unlock that door. He didn't climb up on the coffee table. He didn't go over and find the key. And you talked about how hard it was to unlock the lock. All this didn't happen, okay? You, Alex, Crystal, somebody did something to little Joe and took him out of the house, and you know where he's at now. Next page, 132. Agent Faulkner. If you didn't do it, then you know who did. Agent Boyd, tell us what happened to baby Joe. You, Alex, or Crystal did something to him. I didn't do anything to him. I'm telling you the truth. Agent Boyd again. You, Alex, or Crystal did something to him. You know it is, and you know where he is. At the beginning of this, I asked you, what would make you lie? What would make you tell someone you killed your son? Page 134. So it was you that did something to baby Joe? No, I didn't do anything to baby Joe. Well, Crystal was sleeping. I'd hate to think Alex did it. But maybe he did. Mr. Daniels thinks that the only thing they know is whatever Alex told them. Agent Boyd is threatening to investigate Alex. The next page, page 135. Agent Boyd, I understand that. What I wish you would believe me when I told you that no matter what you tell me right now, you tell me the truth, you'll walk out that door. You're walking out of here, okay? I promise. I can promise you that no matter what you say right now, you're walking out that door. He's asking him to say Alex did it. He's telling him that he needs him to tell him what happened. They already know Joe's dead. They've already talked to Alex. We need you to tell us what happened. People don't walk out of the door when they admit to murder. Page 146. At this point, Mr. Daniels is starting to tell them stuff that he may have blacked out and done. He doesn't remember anything. He may have blacked out and had some subconscious action that took place. Joe Daniels says, there's stuff that happens that I don't remember. And Agent Boyd says, tell me what you did to baby Joe. I need you to look up at me, okay? What did you do to baby Joe? Agent Faulkner, Joe, you could have blacked out and don't remember what actually happened. And you know, afterwards what happened, right? I mean, you don't remember physically, but you could have blacked out and done something accidentally. But afterwards, you do remember the results of what happened. So Agent Faulkner starts telling him, maybe you blacked out. Mr. Daniels, at this point on the next page, says, I let him out. He doesn't say I killed him. He tries to give them something. He doesn't know what Alex has told them, so he says, it was me. I let him out. Throughout this entire time, he continues to say, I blacked out, I don't remember, I don't remember. On page 155, he says, I didn't do anything to Joe. I don't remember touching him. There are things I don't remember. Agent Boyd says, tell me what happened to baby Joe. Joseph says, okay, I unlocked the door, I pushed the coffee table out of the way in a weird way. I don't know why. I don't know what happened. And I let him out. I told him to get out. I don't remember doing that. And Agent Faulkner says, you remember that, right? Even Agent Faulkner is questioning whether these are statements of reality or something he's just making up at this point. Page 163, at this point, he's let him out of the house, he's chased him down, he's brought him back, he's chased him down. Remember in Alex's statement that he was woken up by a noise? The state's arguing two sides of the same coin right here. They're saying that nobody would have heard little Joe sneak out because the door slams. They're also saying believe his statement because he's let Joe out twice, he's come back in, but the first time Alex hears anything is when he's thrown down on the coffee table. Page 165. Joe Daniels. Alex is a witness, right? That ends with a question mark. He doesn't know if Alex is a witness. Agent Boyd says, yeah, I hear you. The next one in the transcript doesn't have a question mark. It should, because he says he saw everything. Boyd then continues to question about what happened. But Mr. Daniels doesn't know if Alex saw anything. Page 175. Yeah, I'd realized that I didn't know what was going on the night before. It's really hard to, when you black out like that. I don't remember what happened until you sit here and think about it, because they're telling him over and over again, stop thinking about what you have to say, just tell us what happened. He said, well, I don't remember it. Apparently I had to black out, so I'm having to think about what could have happened. Page 179. I'm actually going to move back to page 178. Throughout page 178, they're asking him when he told people. What did you tell Crystal? When did you tell, what did you tell Crystal about this? I haven't told her. When did you tell her the story? About Joe being gone? About all the stuff you're telling us? I never told her. When did you tell her the story? I haven't told her. I haven't told anybody. When did you talk to Alex about it? I didn't tell him about it either. You didn't have to. He saw. Agent Boyd once again affirms to Mr. Daniels that Alex already knows. He saw it. You didn't have to tell him anything. And what does Mr. Daniels say? Are you suggesting that I killed my son? He's still trying to figure out what it is Alex told him. I'm asking you, when you told Alex about it, you talked to Alex about it because he saw. Alex, this is now Faulkner, Alex saw what happened, and Alex has been coached on what to say and what not to say, but he'll eventually tell everybody what he saw. Agent Boyd, what did you tell Alex? I didn't tell him anything. Agent Boyd, you didn't have to because he saw. What did you talk to Alex about? About him not being there? All about it, or about it all. Joe Daniels, I haven't told him. What did you tell Alex not to say? Joe Daniels, that's part of when after he was, I let him out. What did you tell Alex? That if he would tell anybody I was going to beat him. That's what he said, right? That's what he's told y'all. He's asking them. I told him I'd beat him, right? That's what y'all want me to say? That's what he told you I said? Agent Boyd, I believe you. What else? Page 192, he tells them that he put the body on McElhaney Road. Why would he do that? Because on page 125, for whatever reason, Agent Faulkner says, tell me about the dirt road. What happened on the dirt road? He thinks that something happened on a dirt road. So he picks the nearest one to his house. You'll have your transcripts. You should read it all. Because when you read through it, you can tell that he denies it, he denies it, he denies it, all the way up until he's promised nothing will happen, and he's told that they're looking at his son. I'm not going to call Alex Nolan a liar, because he's not. He's a child. He's 12 years old. He got up here and he presented to you the facts he's been given. You watched the video of him almost immediately after he finds out that his father confessed to this. And when they say, your father did it, he says, why would he do that to little Joe? He doesn't say, yeah, beat him to death in the living room. He told me not to tell you. No, he's confused. For an hour they question him. For an hour they tell him not only that he saw it, not only that it happened, but that his dad told told him that he saw it. His dad says, tell Alex. Alex can tell you the details. Because he does say that. In the confession, he tells them. They ask him for more details. He says, ask Alex for the details. Why? Because he doesn't know what happened, and he doesn't want to mess up whatever Alex said. He's guessing. He says he's talking to them about stuff he did subconsciously. He says multiple times in the interrogation, he's speculating. And then when they take him out there, he asks Agent Trevor Daniels, he says, what did Alex say? And when Trevor Daniels says, I can't tell you, his response is, he's a good kid. He doesn't lie. We've taught him not to lie. Believe him. Alex's story's changed over time. It's not his fault. I'd say the person who's most responsible for that change is Mr. Daniels, because they've confronted him over and over again with this confession, and they've tried to make his story match what they think is reality. Because the confession is that he beat his son to death in the living room, which the state is going to argue they can't prove to you because there was no evidence of it, but that they don't have to prove it to you because it's possible, and they can argue that maybe there just wasn't evidence. Alex is a victim in this case. Alex has been put through 50 interviews, interrogations, therapy sessions, whatever you want to call it, and been told that his reality is not true. He didn't go to sleep that night and then wake up and his brother's missing. That doesn't fit with their story. After the confession comes out, the TBI comes in the house. They brought in people who checked for blood. They checked the walls. They tore the carpet out of the house. They tested other things for bleach, and now they're going to say there's a spot that could have been bleached, but they didn't test it for bleach. And they also testified that even if it was bleached, they still think they would have found blood there. They didn't find any blood in that house. They didn't find any blood in the car. They didn't find anything on the trash in the car. They didn't find anything in the trunk, in the interior. They brought in shovels. They tested those. They found my client's DNA on the handle of a shovel he owns, his father's DNA on a handle of the shovel they own, and they say that was from sweat and contact. None of those things are proof of a murder. They don't have any proof of a murder. They checked the shovel for bleach. They showed you that they could have chosen to check to see if that spot was bleached. They didn't. They never found Joe Clyde Daniels. They stopped looking. They said, he's confessed, that's enough. They don't even have proof that he's dead. How can you convict somebody of murder when they don't have proof that he's dead? He could have been picked up and taken. They didn't check into the neighbor. They didn't even take his phone. He could have been walking down the road. Someone says they saw him 6 miles away. I'm not trying to tell you that's realistic. I'm just telling you it's possible, and they didn't look into it. They had their confession. They were done. The judge is going to make it, he's going to give you a lot of instructions, and I'm sorry, but you're going to sit through several minutes of him reading. But I'm going to read this one to you. It's on the very beginning. I want you to pay attention to it when you get back and you're deliberating. The nature of a homicide in a case is the body of a crime, or the Latin terms corpus delicti. Corpus delicti consists of 2 elements: the death of a human being and criminal agency in producing that death. Implicit in the latter is that the requirement of the state to prove that the death was not occasioned by natural causes, by accident, or by the deceased person. Corpus delicti means body of the crime, and the corpus of delicti of a crime must be proven by the prosecution beyond a reasonable doubt. To establish the corpus delicti, the state must show a certain result has produced and the result was caused by criminal agency. The identity of the wrongdoer is not part of the corpus delicti. The corpus delicti may be established by circumstantial evidence, but when circumstantial evidence is the sole basis of proof, the facts proven must be consistent with the hypothesis of guilt and must exclude every reasonable theory or hypothesis. That means that not only do they have to prove this to you beyond a reasonable doubt, they have to prove to you that there is no other reasonable theories about what could happen. Is it reasonable that someone left that lock off? Is it reasonable that one of the parents forgot to lock the door and the child went outside? Is it reasonable that someone could have picked him up while he was out on the road? Is it reasonable that a child walking down a highly trafficked area could have gotten hit by a car and maybe they decided to do something with him? He's not there. They searched. It's been testified over and over again that this was the largest search in the history of Middle Tennessee. They had helicopters. They had people walking shoulder to shoulder with GPS units. They had more tracking dogs than the lead detective can say. And they didn't find anything. The idea that he walked down the road carrying the body, and the agent testified that if he got tired, he could have set it down. No, that's not possible, because they had tracking dogs there. They would have tracked him down the road, especially if every once in a while he was setting the body down, but they didn't. Alex says that he watched him walk outside and set the body down in the yard, but that didn't happen because they had dogs all over that place and never one did they hit on that area. The state's argument is illogical. The state's argument is that my client is a liar, but you got to believe him. He lied to you. He lied to the police when he called 911. He lied to the first responders when he told them what happened. He lied to Detective Trevor Daniels when he showed up and asked him what happened. He lied to Miss McCartney whenever she showed up and was questioning him. He was lying the entire time he was in that car talking to her. He lied to Agent Kennard. He lied to his dad. He lied to his wife. He lied to the Agent Boyd when he got there. He lied about all the things that happened in his confession because he didn't use the car. He wasn't out on McElhaney Road. All those things are lies. He's lied to you about everything, but you got to believe him. He killed his son. That doesn't make any sense. How can you ever rest your head easy at night when they can't even prove this child is dead? How could you find someone guilty of a crime based solely on their confession when everything they said wasn't true? When you go back there and you're looking through this, look at what they gave you. Think about what they didn't give you. They never gave you any proof.
Crouch.
Ladies and gentlemen, I too would like to thank you for your service over the last many days and your attentiveness to the evidence that's been presented. I hope that we, and myself and the staff here, have presented the evidence in a reasonable and professional manner with as much dignity as we could. I hope you noticed right out of the gate, with the defendant's argument that the only confession he's even disputed was April 6th at Agent Boyd. But what about right after Agent Boyd, when he's in the vehicle with Trevor Daniel? Trevor Daniel's not asking him any questions at all, none. So how is that a false confession? And y'all listen to 13 clips from Trevor Daniel's vehicle. 13. No questions asked. These were just spontaneous statements made by the defendant, all claiming to either have killed his son or claiming how honest Alex is, that he's a good boy, he wouldn't lie, and he told him not to lie. These are unsolicited. Nobody's asking him questions. So you know they're not false. There's nobody there asking him anything. They're just listening. What else does he say as they're driving to McElhaney Road? I want all the money that's been donated to go to the funeral expenses. My dad is going to kill me. My dad is going to kill me. And the detective does speak and reassures him, we're not going to let that happen. Why would his dad want to kill him? Why would the defendant's own father want to kill him? Because he has killed. He committed murder. He killed his own son. And he's now in fear that his father will be mad, and rightly so. But all of those comments, all of them, unsolicited, no questions asked. They're just him talking. You know, false confession when someone's just talking. Let's go a little further in the night. He then acknowledges that he has lied about the location of the body and gives a written statement, a written and signed statement, confessing again to the murder of his own son. How is that false? How is that coerced? He freely and voluntarily does these things. Now, go forward to the next day. The man requests to use the phone. He's not forced to use the phone. He requests to use the phone and calls the TBI and tells them he wants to help bring closure. If you're giving false confessions, why do you want to help bring closure? What he's doing, two things. He's still fishing for information to see what has been learned in this case. Why? Number one goal of the defendant, conceal, 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 conceal. He wants no one to see what he has done to this child. But he's the one that picks up the phone, mind you, for the second time, because the first time he picks up the phone is to initiate the false report. Go forward 2 days from the false report, and he picks up the phone at his own request and calls the TBI and has them come up there and drive him out to the command center and then to Love's. And he admits again, I've killed my son. I've killed my son. I've thrown him off a bridge. How's that false? How's that coerced? He is the one that initiated. He is then taken over near the command post where his father is present. His own father gets in the vehicle with him. He tells his own father, I killed my son. I killed Alex. I beat him. Is that coerced? Did his father coerce him now? When you have nothing else to argue, you argue false confession. When you have nothing else to argue, you argue false confession. And that's what the defense is doing. That's what they've been doing. Think about how badly they berated Jeannie Jones, who took the stand, came forward on her own, made a call saying what she observed. And Mr. Locker wanted so badly to get her to say she didn't see somebody there. He tried every little trick he could to get her to say she was looking in the woods.
You can't imply that counsel's using tricks.
Counsel will refrain from trying to imply that there's any sort of deception or any sort of effort or logic on the part of the opposing counsel. But ladies and gentlemen, again, argument of counsel is not evidence. It's just their explanation to you about what they believe the proof has shown. You will recall the testimony and you will recall the questions that were asked and the answers that were given.
He stood here and cross-examined Ms. Jones to the fullest extent he could to try to get her to shift away from the fact that she saw the defendant and he was wearing red shorts and a colorful shirt. That's indisputed. Now, the coloring on the shirt, red, white, and blue, black, bright green, that's debated. The color of the shorts, red, absolute. He didn't even ask about the color of the shorts. And guess what? Guess what the defendant is wearing on April 6th when he gives his first confession? You see it, you saw him in the video. He pulls them up. He's asked, what shorts were you wearing when this occurred? He lifts his belt, pulls the red shorts. These. How's that coerced? How is that coerced when you just show the shorts you're wearing? It's a very simple question. Who would be coerced by asking, Ray, what color tie are you wearing? Navy. He didn't have to say these are the shorts I'm wearing, but he did. What shirt were you wearing? The alien shirt. It says, I believe. Did you wash it? Was the question from Agent Boyd. Yes. Okay. Where was the shirt found? In the laundry room. In the dryer. Confirming it had been washed. There's no false confession. Let's go back to what Alex said in one of the CAC interviews. This is a hoax. This whole thing was a hoax, and it was. A hoax that family had been forced into perpetrating forward out of fear of the defendant. Alex was threatened to be beaten and killed. And Mr. Mitchell wants to talk about what Alex said in his statement to the Child Advocacy Center, but don't forget his own father was there with him, standing right outside the door. And just 2 days before, I'd been told you will be beaten or I will kill you if you talk about this. An 8-year-old boy. What are you going to do if you're an 8-year-old boy and the man that you saw murder your brother is standing outside of the door waiting to get you after you finish this Child Advocacy Center interview? What are you going to say? That didn't do anything. But Alex does eventually talk. And it is untrue that he was interrogated 50 times, as suggested. He was questioned twice at the Child Advocacy Center, and you heard testimony that he had therapy from a doctor, not interrogations from law enforcement. See, that's kind of the thing. If you don't pay really close attention, you might be hoaxed or tricked or believe that he had actually been interrogated 50 times by law enforcement. But that's not the testimony in this case. He was questioned by a forensic interviewer at the Child Advocacy Center 2 times. Everything else was therapy sessions with his doctor, which we know nothing about. He wasn't interrogated. Let's not forget that this entire story about moving the coffee table over to the door, that's not something investigators came up with. That's what the defendant said happened. That the table was moved over to the door, that Alex got on the table, that Joe Clyde got on the table, unlocked the padlock, and you know the rest of it, put the key back on the nail, hid the lock in the box, moved the table back. Well, let's talk about this. Would any 5-year-old have the competency and foresight to return the table back to the center of the living room to conceal that they had escaped the house? I don't think so. I think that's planning to conceal your escape. If you're gonna put the key back on the mantle and then move the table back to the center of the room, I don't think any 5-year-old could do that. But we know Joe Clyde can't. I mean, it's global developmental delay. He's not the normal 5-year-old. He is struggling as a 5-year-old. He can't do a lot of things that other 5-year-olds can do. But he definitely doesn't have the mental forethought to be able to say, okay, if I want to get out of this house without my parents knowing it, I'm going to move this table back over here where they don't know that I've escaped when they wake up in the morning. He didn't do that. But that's the story of the defendant. It's a hoax. A hoax. They called 911 knowing that it was a hoax. And just to be clear, in order for you to believe that hoax, they wanted to set it up that way. The defendant says in his statement, I put the lock in the box. He's saying, I put the key back on the mantle and I put the lock in the toy box. That's what the defendant says. That's not coerced from him. That's his story. How would Joey Boyd or Agent Faulkner know to say to the defendant or coerce him into saying he put the key back on the mantle or put the lock back in the box? They wouldn't know to say that. That rings of truthfulness. Why? Because that's where the lock was found, and that's where the key was found. The shirt found in the washing machine, in the dryer. If you'll go to the first slide. You've already seen this. This is Alex and Joe Clyde getting off the bus on April the 3rd. Now they're getting off the bus at the end of the driveway. Aunt Joyce is waiting for them. Not their parents, Aunt Joyce. Now, Aunt Joyce is waiting for them at the end of the driveway, walks them back up to the house. These kids play outside. Presumably they play outside and in the yard all the time. You heard no testimony that a dog ever hit anywhere in the house. But the defense wants to make you think, well, a dog didn't hit in the house or around the house, so nobody was killed. Because that's not actually the testimony you heard about dog handling. It's presumed that the scent of the folks that live in that house will be all around it. A dog will not be tracking on the house where the person lives. I mean, that's just common sense. Those kids walked right there, April 3rd. Joe Clyde's scent was being left going up the driveway, but a dog didn't hit on the driveway either. That's because they don't want you to understand how tracking dogs actually work. So because there was no hit in the yard, that means nothing. The scent of the resident is presumed to be there. It is there. They live there. So chip away, chip away, chip away. Next slide.
There was a padlock. Okay. Now those doors, on which door was the padlock? The back door. The back door when we came in.
That's April 4th to Agent Kennard. It was padlocked. He didn't say, oh, I don't know if it was padlocked. It was padlocked. Now, is this a coerced statement as well? Is this a false confession? No. This is the defendant saying, hey, we padlocked this door. And you know what? The evidence has shown that Joe Clyde previously did leave that house. But that's why they started putting a padlock up, so he couldn't get out. And you heard testimony that since they had begun using the padlock on that door, Joe Clyde had never gotten out again. You also heard testimony that he never got out at night. He never left that house at night. Except on this occasion. And isn't it also odd that on this occasion it was raining, thundering, and lightning, and he wanted to go out at night on this night? No. Because you've already heard testimony from Jessica Donnerstag and the defendant. He didn't like loud noises, and he did not like playing in the rain. Did not. So he's going to go to this great length of moving all this stuff around to go outside in a thunderstorm and rainstorm? No. No.
Does he like playing out in the rain? No.
No, he doesn't. But yet on a night when it's thundering and raining, a child, a 5-year-old with global developmental delay, who scores in the first percentile of his gross motor skills, elects to escape the house? No. And Mr. Mitchell was right. We need to exclude reasonable theories. The theory that he left this house that night is not reasonable because it didn't happen. He left that house in the arms of his own father after his father had slammed him into that coffee table. A noise so loud that it woke everyone in the house up. Everyone. Alex comes out of his bedroom and what does he see? Crouched on the other side of the living room, Noah and Aunt Joyce. How do you corroborate that? He's dead. He's dead. He's dead. That's what Noah says the next morning. As 2 independent eyewitnesses are filling out a missing person questionnaire. Think about that. The defense just told you in their closing there's a house full of law enforcement telling everybody in the house that Joe was dead, which is why Noah asked, is he dead, is he dead, is he dead? That's untrue, factually untrue. The testimony from every witness that got up here said that TEMA and the Murray County Search and Rescue Team, Brent Morris, Chad Bailey, were there to fill out a missing person questionnaire. Not a dead person questionnaire. It's a missing person, a missing child. People were responding from all over Middle Tennessee to search for a missing child, not a dead child. Nobody had said that child was dead until Aunt Joyce did. Not one law enforcement agent or person that took this stand testified they had told anybody in that house that baby Joe Clyde Daniels, was dead on that morning. That is an inference that the defense wants you to make because they want to explain away why Noah would say spontaneously, not coerced, spontaneously, he's dead, he's dead, he's dead, to be confirmed by Aunt Joyce, which puts him in her arms and says, yes, baby, he's dead. Don't buy the hoax that the defendant started spinning on April the 4th. That's the next slide.
We found the key, we found the lock.
Oh, you did?
Yeah. The lock was thrown into the toys. The key was on the mantle, oddly enough.
Oddly enough, the key was on the mantle. This isn't a coerced interview. This is Agent Kennard on the night of April 4th in the defendant's home, sitting next to him, asking him questions. He wasn't being forced or coerced. He's saying, oh, yeah, we found the lock. Right. Yeah, because you put it there. We later learned. Next slide.
Where do you put it?
It was on the mantle. I put it on the mantle.
Okay. Is it just sitting out open on the mantle?
Yeah.
I put it on the mantle. Next slide.
I have a very second temper, so I've done it a couple times.
Yeah.
I regretted all of it.
Sure. With Joe specifically?
Yeah.
So that's April the 4th with Agent Kennard. So move forward 2 days, and you've seen the video of the defendant. Why did I kill my son? Because he snapped. he went into a rage and he killed his son.
Is it reasonable to think that he could get out of the house without anybody hearing anything?
That door is right next to our room, so we can hear it.
Mm-hmm.
And normally when someone opens the door and closes the door, we can hear it, but
Again, the defense says we'll exclude all reasonable theories. There you go, he just excluded it for you. That door is right next to their bedroom, and when somebody goes in and out of it, they can hear it. But they didn't hear anything because, why? The defendant was up. He's the one that went out the door with the dead child in his arms. We are excluding these theories because they're a hoax.
but I did check it before I went later in the evening.
All right, now this is a different interview. This is when he's writing with Detective McCartney and Detective Lovell. And again, he tells them, I did check the lock. I checked the lock. So we're doing two things simultaneously. We're showing you, one, that the defendant is lying when compared to his confessions. But two, we're also excluding the theory that the door was somehow unlocked and that the child escaped. We've crushed that theory that it was unlocked and he got out of the house. And unless it was unlocked and he got out of the house, then everything else that Mr. Mitchell told you about these possibilities is impossible. Kidnapping, car running over him, impossible. Because he couldn't get out of the house. The only way he could get out of the house that night they checked it. Why did it become habitual? Because they didn't want him to get out.
But and he slams doors, he did not slam that door.
When he goes out that door, he slams it. But he didn't slam that door and he didn't wake him up because it didn't happen. Because the only time Joe Clyde Daniels went out that door was in the arms of his father.
Does he ever get up in the night and wander around inside the house?
Yes.
He does?
Yes, he does do that.
And you guys hear him when he does that, or?
Yeah, because we'll go to like the pots and pans and play with it. I play with the, canned goods.
You heard the testimony of Miss Donnerstad. With his global developmental delay, Joe Clyde could do some things, but a lot of things he couldn't do. But he was not, and I think I specifically asked her the question, is he stealthy? And she said no. He's not stealthy. He doesn't do anything quietly. And in the words of his father, yeah, he gets up in the middle of the night some, and we can hear him because he'll be playing with his toys or banging around pots and pans. But yet they want you to think that he pushed the table all the way across the living room, up to a door, through the toys, by the way, through the toys. I guess he picked all the toys up. Climbs up, finds the key, unlocks the padlock, puts the key back on the mat, then pushes the table back to the center of the living room. Nope. Not reasonable.
So there's never been a time where y'all have forgotten to lock it or just left it open for just a little bit by mistake?
I usually check to make sure it's locked.
Did you check it last night?
No, but she did.
And there you go. It's a double system there. I check it every night, but if I don't, she does. They're communicating with each other, at least that's the story they're telling. We check these locks, we check these locks, we check these locks.
So I don't know how. But I usually would have heard something because he actually slammed the door and I didn't hear that, so.
Again, a second separate interview altogether, and again, he says, Joe Clyde, he slams doors. This entire position they've adopted that he somehow got out of the house, it's baseless. It's absolutely baseless. He was killed by his father and taken out of the house.
room with you?
Alex.
Who is Alex?
Alex is Joe's, is Crystal's son, my stepson.
Okay. So,
Okay. I wrote this down, just so I could get Mr. Mitchell correct on it. He begins by saying that Agent Boyd knew certain information about Alex from the Child Advocacy Center interview, so he was confronting Joseph at this confession on April the 6th. But that's not correct. How do we know that's not correct? Because Agent Boyd was not at the Child Advocacy Center interview on April the 5th, the day before. So keep in mind, the defense is saying, okay, the TBI is injecting information into this interview, and he's creating a false confession from information provided by the TBI. Agent Boyd was not at the Child Advocacy Center. He didn't hear anything Alex had to say. Not only that, play that clip again.
room with you?
Alex.
Who is Alex?
Alex is Joe's, is Crystal's son, my stepson.
Okay. So,
Agent Boyd said, who is Alex? Agent Boyd doesn't even know who Alex is at this point in time. Who is Alex? So what they're trying to get you to believe is that Agent Boyd injected all this false information, and that's how he adopted a false confession. Agent Boyd wasn't at the Child Advocacy Center. He has no clue who Alex is or what Alex said. There you go. There was no false information injected into that. You can hear Agent Boyd in your own ears say, who is Alex? Next slide.
Alex is a witness, right?
yeah, I hear you.
You saw everything.
Alex is a witness, and I agree with Mr. Mitchell. That's kind of posed as a question. And Agent Boyd says, yeah, I hear you. He doesn't say, yes, he's a witness, and he's ratted you out. He doesn't say that. He just says, yeah, I hear you. Play that again.
Alex is a witness, right?
Yeah, I hear you.
You saw everything.
He saw everything. He's fishing for information again. He already asked, whose phone left the house? He wants to know. He wants to know what Agent Boyd knows, so he can adopt a story to get out of trouble, to conceal, to keep them from finding the body. He saw everything, right? He's wanting to fish Agent Boyd. As Agent Boyd testifies, he said, there's always two sides to an interview. There's what I know and there's what the suspect knows. And we're always engaged in that, trying to figure out what the other one knows. That's the testimony of Agent Boyd. So in the beginning of this interview, the defendant is fishing to see what Agent Boyd knows. But as it comes out, we know that Alex actually is a witness. And remember, Alex hadn't ratted out the defendant. He didn't say anything at the Child Advocacy Center because his dad was standing right outside the room.
What did you tell Alex?
That if he would tell anybody else, I'm gonna beat him.
So what
That's
did
what
you
he
tell
said,
him?
wasn't it?
See? That's what he said, is that if he told anybody, I was going to beat him. That's what he said. He's asking Agent Boyd. That's what Alex said, right? Well, Agent Boyd wouldn't know because he doesn't know who Alex is. He's not had an encounter with him. Go ahead.
What did Alex do when he saw
He was,
what happened to
he was just,
Baby Joe?
he was just watching. He didn't do anything. He was just watching.
Does he know that Baby Joe's dead?
Yeah.
Alex does. Did he say that?
No.
Did you tell him?
No.
He just saw.
Yeah.
Did he say anything to you about it?
No.
Has he asked you where Baby Joe is?
No.
You just told him if he told anybody about it, just beat him?
Yeah.
How is that coerced? How is that coerced? Do you see anybody yelling or screaming? Agent Boyd is just, what did Alex see? He saw everything. Alex did see everything. The defendant is admitting that Alex saw everything. Alex is the corroborating witness, who, by the way, was threatened by the defendant. Now, I didn't think we were going to have to address this again, but I put this slide in here because I had a hunch it might come up again. How many witnesses testified that that report from Gilliam Hollow Road was searched multiple times, but yet the defense has argued again today that nobody did anything on Gilliam Hollow Road? You've got the documents as an exhibit. 3 separate searches on Gilliam Hollow Road. But they're trying to say, oh, they didn't do anything. They didn't do enough. 3 times, and it was unfounded. They're saying these boots were stolen. Well, that was the second report from Gilliam Hollow Road. The first one came in that there was footprints in the barn. They went and checked. Detective McCartney, there were no children's footprints. There were goat prints. And the caller wasn't happy. They called back. A pair of boots had been stolen. That time, they sent the captain over there with a crew and it searched. What did they find? No evidence of a child being anywhere. None. But why is the defense trying to ingrain in you that law enforcement didn't do their job when we've proven over and over and over again that they did? And then the caller complained one more time. And when they first responded, she was asleep, wasn't even home. But they still went and still searched again. There was 3 searches at Gilliam Hollow Road. Period. And you know, the way the questions were asked and the inferences were drawn from the defense through some of the witnesses. Remember we were discussing logic and reasonableness? These reports from Gilliam Hollow, just think about how actually logical this is. They exclude each other. Because the lady at Gilliam Hollow said things happened 3 days in a row at her house. And all the way down here, 12 miles away in a different county, we're in Dixon County, all here. This is the Humphreys County line, right here. On the same day, a 4-year-old at this house sees something, somebody in pajamas and shoes. Well, those exclude each other because if somehow Joe Clyde had gotten out, he wasn't in 2 places at the same time. But nonetheless, law enforcement did go here. And you heard testimony of the report and investigation they did when they went there. Not only did a deputy go there, others did as well to search. Both of these places were searched. So why are they still arguing that law enforcement didn't do anything? I don't understand that. And you should be questioning that too. Why are they trying to convince you that law enforcement didn't do anything at either one?
Objection, Your Honor. The only thing we asked about was doing a dog search. We never said they didn't do anything. Only they didn't do a dog search.
Ladies and gentlemen, you will remember what the evidence was and the questions that were asked. It is you are the determiners of the facts in this case, and so argument, but both sides get to argue what they believe the evidence showed. And I'm overruling the objection simply because of the fact that both sides are entitled to argue what they think the evidence has shown and the inferences that you can draw from it. But you are the sole judges of the facts in this case, and you are the ones who should remember what the evidence showed or did not show. Thank you.
And ladies and gentlemen, I'm arguing this because, as Mr. Mitchell said, the state, we're excluding these reasonable theories. It's not reasonable to believe that Joe Clyde Daniels was here and on the same day here. It's not only unreasonable, it's impossible. Impossible. It's unreasonable to think that Joe Clyde Daniels, at 5 years old, traveled northbound across Highway 70, a major traffic area in Dixon County, went to Gilliam Hollow Road, stole a pair of tennis shoes, snuck into the barn, camped out, moved a horse blanket, woke up, went back south. By the way, going south, crossing Highway 70 again, takes him directly into the command center where hundreds of people were gathered. Hundreds. So it's impossible and unreasonable to even suggest that that's what occurred here. Walking either one of these routes would take him right through the command center, all the way over here, where at this point he's changed shoes again. No. No. He didn't go to Gilliam Hollow. He didn't go to Humphreys County because he was murdered by that man sitting at that table. But the defendant, started this hoax. He started it, he initiated it with that 911 call.
That boy is not as weak as people think. That boy is a strong boy.
That boy, ladies and gentlemen, is his 5-year-old son. His name is Joe Clyde Daniels. That boy is someone who the defendant should have been caring for, not hurting. The defendant to this day, let me back up. We don't know where Joe Clyde's body is because the defendant has concealed the location of that away. Joe Clyde Daniels. We know the defendant questioned, leading up to his death, whether he was even the father. How do we know that? Because he was searching paternity, ways to test paternity without the mother knowing. You can see that on his Google search tab. That boy. That boy.
Hey, Joe. What is it that you're wanting? Hey, Joe, look at me, buddy. Look, I don't have an apple. I'm so sorry. Do you want me to bring you an apple on Thursday? Are you so mad at me because I don't have apples? Hey, be nice. I'm sorry. I really am sorry. Don't be so mad. We're going to play a fun game instead, okay? No, you want an apple more than anything? Be nice, okay?
Joe Clyde wanted an apple. And I'm almost finished. And I am mindful of your time. But this is important. And this is our one opportunity. You can see the determination on his face and the disappointment when he asked for an apple. Man, this is a case that'll give you the black rings under your eyes. So bear with me. I ask you on day one, almost every one of you, how would you feel if you were at Walmart or a water park or at home and you noticed that your child was missing? And pretty much the unanimous answer was panic. I think that would be the normal feeling of any parent, panic. What we see from the defendant is not panic, but pretending. How do we know it's pretending? When he leaves his house, he drives to Love's on the morning of April the 4th, all the way to Love's. He knows Joe Clyde didn't walk 9 miles to a truck stop. He knows that. This guy isn't panicking. He's calling Nashville State Community College. But they want you to think they argue to. He was searching for a son like any person would do. No, you all know. You know what panic is, and you know what it's like when you're wondering where your child is. And you ain't calling Nashville State Community College, and you ain't downloading apps on your phone to get your transcripts and W-2. That's not panic. That's pretending, and lack of concern, and lack of emotion, and lack of panic. That's what the defendant did. When I asked Agent Burkhardt about the call to Nashville State, Mr. Lockett cross-examined and said, well, he's got a right to earn a living for his family. Sure he does. But there were hundreds of volunteers that came to Dixon County on April the 4th and gave up that day's wages to actually search for Joe Clyde Daniels, to do a real search. Not just slowly driving down Garner's Creek, but to do a real search by land, by water, by road, by UTV. Real people, really invested. But he's calling Nashville State Community College because he's panicked for his son? I won't ever see another apple without thinking about Joe Clyde Daniels. He stomped his foot because he wanted an apple. Stomp your foot. Don't buy into a hoax. The state has the burden of proof in this case, and as I told you in my opening statement, we will honor that. We committed to proving beyond a reasonable doubt. But I also ask you to follow the law from day one. The law does not require us to produce the body of Joe Clyde Daniels to you. That's not the law. Please do not reward the defendant for his successful and continued concealment of this child's body.
Ladies and gentlemen, it is noon. What I'm going to have to read to you in that charge is going to take a considerable period of time for me to do so. I think it would be appropriate now for us to break for lunch. I would just remind you that, as I have previously instructed you, you should not discuss this case, even these closing arguments among yourselves. You should not discuss any aspect of the testimony that you've heard. Do not start deliberations or do anything like that. Just enjoy your lunch, and then as soon as we come back from lunch, I will give you the final charge, and after I've given you the final charge, we will select the 4 alternates that will be discharged from service, and then the remaining 12 will go back and begin their deliberations. All right? And at this point, we're going to ask you to go ahead and step across. Mr. Etheridge, were you given the charge, or are you going to put that on the screen?
Yes, sir.
All right, just for your information, the jurors are all going to be given their own copy of this 30-something page charge to go along with me when I read. But for the benefit of everyone else, I think some people are at the council table and so forth, maybe looking on the computer. We're going to have that charge demonstrated on this large screen TV so that anyone else can follow along with us as well. We will be in recess. Let's make it until 1:15 for lunch, and then we will come back and begin the charge of the jury. 1:15.
All rise. This court is in recess for 1:15.
Where's your feet here that you recommend outside of? Courtside Cafe up the street in that little triangle. Or you've got the Country View Market, they make great sandwiches.
Oh, inside the market?
Yeah, they've got a deli, you just go up there and on a piece of paper like this right here.